have just a couple of minutes. I'd like to circle back to each of you for just a few seconds or so. Any final closing remarks you'd like to share with our attendees today? Nathan, we'll start with you.
Yeah, so I can keep this very brief. I would just say that right now there's a lot of, the agencies aren't just aggressive on enforcement. There's also a lot of the kinds of process and policy changes that I talked about, like these warning letters and this prior notice and approval. And so I think what's important is to keep in mind not only these things that have happened in the past few years, but that this might not be the end of it, and that we might be seeing more changes to the process over time. And so, you know, as me and Thomas were just talking about, there are things that you should watch out for, that you should keep in mind, that you should try to think about or discuss with antitrust counsel if you aren't an antitrust attorney, what the implications of are. And yeah, I think there's just a lot of developments, and you should try to keep abreast of them as much as possible.
I think with the trends that we're seeing, it heightens the importance of a really comprehensive analysis internally before the HSR is filed. Look to see what those competitive concerns might be. Talk to the folks that are the major investors in a SPAC, for example. Talk to the folks that are sitting on the board of the target company, if that's your client or if that's who you are. Figure out where their outside interests lie, and be prepared in the event that the FTC or the DOJ ask you about that. Being prompt and really knowledgeable on these issues is really important, and is going to simplify the process significantly for both a client and an attorney.